carefully assessed the information made available to me in light of the sentencing goals of punishment, deterrence, protection of the public, and rehabilitation. I've considered the facts of this case, the defendant's lack of prior criminal history, and her driving history, which was also made available to me. I've considered the arguments and recommendations of the lawyers, their sentencing memorandums, the letters I received, the sentencing guidelines, which were designed, among other goals, to promote consistency in the sentencing process in our judicial system. And of course, I have considered everything I've heard today. I'm also mindful of what the possible penalties are, which is the maximum penalty being 2.5 years in the House of Correction. I also want to be clear about what I'm not considering. Some things that were discussed today, and I want to make the record clear about what I am considering and what I'm not. As to what happened during the course of the arraignment is not for my consideration. It sounds as though there was some confusion over the summons. While I understand that Colin's family feels one way, and I respect that, I am not considering whether her appearance or lack of appearance as far as the sentence goes. I also know that several members spoke about her lack of remorse. It has been my experience through handling cases like this from all sides as a judge, as an ADA, and as a defense counsel, that oftentimes defendants are given advice from counsel not to speak to the family due to ongoing civil liabilities as well as the ongoing criminal case. So this is, while I've heard people make statements such as they've shown lack of remorse, often is the case that they've been instructed not to speak to you. So while again, you're free to feel however you wish, that is your right, please, I would urge you not to take her silence, meaning that she feels no remorse. That is not what I've observed throughout this trial and not what I observed today. As far as, again, I will not penalize her of going to trial. That is her constitutional right, and each defendant has that right and is permitted to test the evidence, which is exactly what happened during the course of this trial. I consider the impact of the crimes on Colin's friends and family and on Ms. Casey, as well as the continuing effects these crimes are going to have on them going forward. I've also considered the impact that any sentence will have on Ms. Casey. When I instruct a jury, I tell them they need to follow the law, whether the charge is popular or unpopular with the public. And as a judge, I expect the same out of myself in determining a true and proper sentence. I also instruct the jury throughout the trial that they are to disregard any sympathy, and they're not to allow sympathy to allow them to sway one side or the other. And today I must do the same. In this matter, there is no perfect sentence that can be imposed. There's no sentence that will satisfy all concerns as the perfect representation of justice. The court must exercise its best judgment upon the evidence presented, the verdict returned, and all the materials and arguments presented at this sentencing hearing as to the appropriate sentence to be imposed on Ms. Casey. While I agree with the defense there should be a period of probation, I also agree with the Commonwealth there should be a short period of incarceration. Consequently, I fashioned a sentence I believe will achieve all these goals. Ms. Casey, please stand. As such, I order as follows. This defendant shall be sentenced to 1 year in the House of Correction, 60 days to be served, balance suspended for 2 years. During that 2 years probation, Ms. Casey, you are to perform 100 hours of community service. And pursuant to the language of the statute, the Registry of Motor Vehicles will suspend your license for 15 years from the day of conviction. Mr. Clerk, if you could read into the record.
Commonwealth now move for sentencing. Colin would so move. Your Honor, may a court sentence be imposed?
Yes.
Charlene Casey, the jury having returned a verdict of guilty on docket 1984 CR 00702, offense 001, charging negligent motor vehicle homicide. The court, in consideration of this offense, orders you committed to the Suffolk County House of Correction at South Bay for a period of 1 year. Court term 60 days of the sentence be served and the balance be suspended with a term of probation for 2 years. You are subject to all the standard terms and conditions of probation, as well as a special condition of probation that you are to perform 100 hours of community service. With respect to fees, the court imposes a $90 victim witness fee and a $250 head injury fee. Those fees may be paid during your probation period. With respect to notices, you are notified that there is a mandatory 15-year loss of your driver's license, and you are also notified that you have a right to appeal the convictions of this matter pursuant to Rule 65 within 30 days. At this time, the defendant stands committed.
Good luck, Ms. Casey.
Your Honor, I believe she has some time.
Yes, sir. How much credit does she have?
Maybe 3 or 4 or 5 days or so, Judge.
All right. Why don't you and counsel, you and the Commonwealth work that out, and I'm sure I will adopt whatever you agree to. Just
very good.
Okay.
Thank you, Judge.
Thank you, everyone. Good luck, Ms. Casey.
All rise, please.
This court is adjourned. Thank you.
You are muted. Goodbye.
Live inside the courtroom after having been found guilty of negligent motor vehicle homicide in the death of little 2-year-old Colin McGrath in South Boston in 2018. Charlene Casey has been sentenced by the judge to 1 year in the Suffolk County House of Corrections, 60 days to be served, the balance to be suspended. She will serve 2 years probation, do 100 hours of community service, and have her license suspended for 15 years. We will have much more on this case and the reaction to the sentence coming up on WBZ News at 5 o'clock and continuing here on CBS News Boston.